my buzz. You shut down, had enough. I'm just looking for that rush. I'm so tired, so fed up of you messing with my buzz. Locking eyes, we just touch. Feel our bodies drifting up. I don't know how to be around you. I'm just trying to lose myself. I know that I just can't trust you, but you know me like no one else. Stuck up in the middle, in between you and I. Maybe just a little.
Tips for dealing with the bank. So perhaps you're renting in a property where it is run by a body corporate.
Understanding the basic calculation, income minus expenses, and you want to be left with a positive income.
It is a very tough game. It's not easy at all.
To stay ahead of knowing exactly what your clients need, what their teething issues are.
Have a joint move-in inspection.
That a lot of people that are coming into sectional title homeowners associations are just like you described, not only first-time homeowners, but first-time owners and residents in community schemes.
They get to see the perspective from the other side of the aisle. And I think that's a really important thing to do.
It's a market that's estimated to be transacting at least 9 billion rand per year. So it's a huge market.
In order to get there, you need to be able to build up a track record.
Your cash flow model needs to be sharp.
A quote comes to mind. The best time to buy a property was about 10 years ago. The next best time is now.
Good evening and welcome to episode 74 of the Private Property Podcast. I'm your host, Zama Khumalo. It's the Monday edition of the show and we've got quite a jam-packed lineup for you this evening as well as for the rest of the week. As many of you have probably wondered, we've spoken about so many things when it comes to the home ownership journey, but a huge bulk of it has focused on buying a property as an individual. And we've certainly looked at the different aspects of doing that. And of course, we're going to continue exploring those. But this evening, what we're going to be focusing on is the ins and outs of buying property in a trust. A lot of you have certainly asked for us to, explore buying into the trust, look at the benefits of buying into the trust, what exactly goes into it, and even asked what exactly is a trust? Is it beneficial for you to buy in a trust? And perhaps what are some of the advantages or even disadvantages should you consider this method of property ownership? Well, that's exactly what we're going to be exploring this evening. And some of what you can look forward to later on in the week is we're also going to be looking at how you can use tax to build your property portfolio. And that's an episode that's coming up tomorrow. And later on in the week, we're going to be looking at the ins and outs of buying property as an individual versus buying it as a company. I know a lot of you certainly are exploring buying property, beyond as an individual, but certainly buying it in a company. And you certainly do not want to miss that one. And of course, if you want to stay up to date with all our upcoming episodes, you can go whether here on Facebook or as well as here on our YouTube channel and press reminder as we've already posted all the upcoming episodes that you can expect this week. You certainly do not want to miss any episode. Well, let's get started with this evening's conversation. We're looking at the ins and outs of buying a property into a trust. And joining me this evening is Peter Dykes, who is the director at Dykes van Heerden Incorporated. Good evening, Peter. Thank you so much for joining us.
Evening. Thank you for having me.
I think, Peter, before we even look at, the benefits of buying into a trust or what goes into it, perhaps let's look at what exactly is a trust.
Okay, so trust is a very difficult concept in a sense that it's what they call an entity sui generis. In other words, it's in its own category. It's very much like a company in the sense that it, for practical purposes, it has its own legal persona. So if you think of a company, it is a legal person and it's treated the same as a natural person in that it can own assets, etc. When it comes to a trust, it's not a juristic person, but it has the same rights and has the same kind of effect as having a company, in the sense that one can then own assets in the trust. A trust is basically formed when a person, normally called the founder or else the donor, decides to set aside a certain asset or a certain amount of money to be held in trust or to be used for the benefit of the beneficiary. So what happens is you have the founder or the donor who is the person who forms the trust. You have the trustees, who are the people who have to look after the trust and run the trust, and then you have the beneficiaries, who are the people who benefit from the trust. So the trustees' job is to make sure that they look after the trust assets, the income and expenditure, and make sure that it runs smoothly and properly and well, but only for the benefit of the beneficiaries. So their job, and that's why they're called trustees, because it involves a large amount of trust, is to do whatever they can to look after the assets so that the beneficiaries can benefit from it. So this was often used in the old days, before women had the right of owning their own property. A father would sometimes create a trust for the benefit of his daughters, so that they could then have the benefit of the property, although they couldn't run it themselves, because then the trustees would run it. And it's that is developed over the years, and now it's used for different purposes. So for practical purposes, not for legal purposes, it's a separate person. It's like a company or closed corporation or an individual. It can perform the same kind of functions as each of those entities can do, but in law, it's not actually a juristic person as such.
So, Peter, a lot of us who've, certainly deal with property, have bought properties perhaps in our individual capacity. Some people have bought properties under a company, and that there are certain things that one essentially has to do. For example, to set up a company, you go onto the CIPC website. It's fairly simple. Within probably 2 or 3 days, your company is set up. What exactly then goes into setting up a trust?
Okay, so generally, if you want to set up a trust, you'd normally see an attorney, and you get the attorney to set up what is called the trust deed, which is very much like the constitution of the trust itself. So that trust deed sets out what the purpose of the trust is, in other words, to look after certain beneficiaries. It sets out who the beneficiaries are. That can either be individuals or a class of individuals, such as the children or the grandchildren, or any class that the founder decides he wants to look after. And then it gives the powers to the trustees that the trustees can use in operating the trust, and the method which the trustees must use when running the trust. So it's like the Constitution. What's important about it is that anything that's not contained in that trust is a problem. So one has to make sure that the trust deed frames the powers of the trustees, what those trustees can do in very broad terms, because a trustee can't act outside of the trust deed. So one has to be very careful about that. And then the trust normally also provides under what circumstances the assets in the trust will then devolve upon the beneficiaries at a certain stage. Sometimes it goes on forever and ever, in eternity. Sometimes the trust ends on the death of the parents, or maybe on the death of the parents and the grandparents, or whatever defined event is stipulated. But until such stage as the trust is terminated, the assets remain in the trust. They're operated and looked after by the trustees, and as I said before, for the benefit of the beneficiaries. So the trust deed would also then set out the manner in which the trustees should make decisions. It might say it must be unanimous, or it might be on the basis that there's a majority of the trustees vote in favor of a resolution, then that would be binding. But whatever the trustee says, that is what counts, and you can't go outside of it other than by going to the court of law and asking the court to assist you, because of the fact that there's a gap in the trust, and the court then needs to fill in that gap for you. So the trust deed is the vitally important document. Normally what happens is the attorneys have built these trust deeds up over a number of years, especially the powers and the methods that the trustees must use. And of course, the clause that is really important is for how the benefit, how the income and the capital of the trust must be used for the benefit of the beneficiaries, how it must evolve. And then there's normally a clause that also provides how one can change the trust deed as well. Very often that's on the basis that the founder and the trustees can agree together while the founder is alive to change the trust deed. And once the founder is dead, normally then the trustees can decide to change the trust deed. But they can only change a trust deed for the benefit of the trust. They can't do it in order to substitute new trustees or something of that nature, new beneficiaries, or to try change the purpose of the trust.
You know, I'm in conversation, of course, this evening with Peter Dykes, who's the director at Dykes Heerden Incorporated, and we're looking at the ins and outs of buying a property into a trust. We've certainly, covered the basics of what a trust essentially is and how one would go about setting up a trust. But Peter, I think one of the perhaps the burning questions viewers at home are probably wondering right now is, why would you even set up a trust? I mean, you certainly explained that in the earlier days, there was, certain justifications for it, certainly where, for example, women weren't able to own property. So it was a great mechanism to ensure that they still are able to reap the rewards of the, let's say, the family estate, for example. Whereas, of course, we know that right now that may not necessarily, that is not actually the reason. Why would one, set up a trust when there are perhaps other mechanisms to share or distribute the wealth of the family?
Okay, so there's a number of reasons why people would set up trusts. The first and probably the most important reason for a trust is to protect against insolvency. A trust is wonderful for this purpose, because if an individual goes insolvent and he owns companies or closed corporations, the shares in the company or the members' interest in the closed corporation will go into his insolvent estate because it's owned by him. However, if the assets are owned by a trust, then they are separate from the individual, and therefore if the person who was the main donor or whatever goes insolvent, then that doesn't affect the trust, unless of course there was some kind of collusion, or that he donated the assets to the trust in order to avoid having a situation where the creditors can get the benefit of the assets. But generally speaking, it's treated as a separate entity, and again I emphasize it's not strictly speaking an entity as such, but it's treated separate, those assets, and that means that if one goes insolvent, then those assets are protected. It's the only way one can protect yourself against insolvency. Now, very often people say, well, I'll never go insolvent, but that simply isn't true, because even a very wealthy person may have an accident and be in a coma for 3 years, and no matter how wealthy you are, after 3 years of not earning income, there's a chance that you will go insolvent. So that would be the main purpose. The other purposes depend on the circumstances. Obviously, a trust can be used for estate planning purposes, both in order to save estate duty and also in order to have a smooth transition when the person dies. So, for instance, if you've own certain assets and those assets are put into a trust, when you die, the trust continues running smoothly and properly. The trustees run it for the benefit of the beneficiaries, and it makes a difference the fact that you've died, so that the trust will continue operating on its own. There can also be very good savings on estate duty, but if your estate is worth more than 3 million rand, because remember, if you don't pay estate duty on an estate of 3 million rand or less. So if your estate is going to be worth more than 3 million rand, there can be a saving on estate duty. And the reason for that is, again, the assets in the trust don't fall into your estate. So when you die, they remain in the trust, and therefore there's no estate duty payable. This benefit has been criticized and attacked on a number of occasions, and it's very possible that in the future the benefit may be taken away. But at this stage, as it stands, that would be one of the good estate planning tools to use in order to try and reduce the amount of estate duty. Generally speaking, the way that you to benefit from a trust is by getting the assets into the trust as early as possible, because the main saving is not on the value of the trust itself, but on the value of the growth in the trust. So for instance, if you bought an asset that's worth 1,000 rand today, and you were to die in 10 years' time, it was now worth 1 million rand, that difference between 1 million rand and 1,000 rand would be the increase in value, which in normal circumstances would have fallen into your estate. But because it's now in a trust, it doesn't, and there's a huge saving. So the best time to form a trust is 10 years ago. But if you can't do that, then the next best time is today or tomorrow, as soon as the program's finished, basically.
And you know, Peter, we're actually going to look at even some of the cost implications to, you know, running a trust, because I'm sure a lot of people are thinking, okay, this seems like the best way certainly to plan your estate. What are some of the financial implications? We're already getting some questions and comments from viewers at home. So we're going to go for a quick break. When we come back, we're going to be looking at that on the one hand, you know, the best time to have set a trust up was 10 years ago, as Peter says. The next best time is certainly today. What are some of the financial implications? But also, what are some of the you know, the implications of them putting properties, especially into a trust? We'll certainly be exploring that and plenty more after this quick break. Welcome back to episode 74 of the Private Property Podcast. I'm your host, Zama Khumalo. This evening, we're looking at the ins and outs of buying property in a trust. If you've ever bought a property in a trust, perhaps share with us your experience or what even prompted you to do so. If you've ever wondered or certainly wanted to buy a property into a trust, perhaps you had a few burning questions when it comes to it, do send them through, and Peter Dykes will be addressing them. He's, of course, the director at Dykes Heerden Incorporated. Peter, one of the questions that we've received this evening is from Usipo Sangwenu, who asks, who can be a trustee?
Yes, so strictly speaking, anybody who'd be able to be a director in a company can be a trustee. So as long as you're an adult, you haven't been convicted of certain criminal offences, or haven't been insolvent, you can be a trustee.
And Peter, sort of maybe let me use myself as an example just to make it easier for viewers at home, because this is something that probably is conceptually new for us. In the event where, let's say, my mom set up this trust, so she would be the one who founded it, and suppose I'm one of the beneficiaries. In that context, am I also able to be one of the trustees, or are the trustees meant to be very separate from who the beneficiaries are?
Okay, so the trustee, a beneficiary can also be a trustee or vice versa. One has to be careful when it comes from a tax point of view. If there's a situation where the receiver believes that the assets have been channeled through the trust in order to avoid duty. So in other words, if you put it in so that you get the income through the trust instead of to yourself, then he'll tax it in the hands of the individual. But say for that reason, the answer is yes, you can be. And in very often in family trusts, at least one of the trustees is the father or the mother, and the beneficiaries are then the mother, the father, the children, and possibly the grandchildren as well.
And Peter, one of the things that you've actually just mentioned, of course, is tax. Perhaps let's explore what the tax implications then are of, setting up a trust, especially within the view of certainly our viewers who have an interest in property and would want to perhaps, place some of the properties that they have, or perhaps even the whole portfolio, into a trust. What are some of those tax implications that we ought to be mindful of before setting up the trust, or as we're in the process of setting up that trust?
Okay, well, and you're kind of asking about the pros and cons. Not really a tax thing, but I'm just going to mention it. Obviously, it costs money to form a trust, and generally speaking, it would be in the vicinity of about 5,700 rand, inclusive of that, to set up a trust. The second thing is that a trust, generally speaking, has to be audited by an auditor, so once a year. There are exceptions if the trustees are considered by the master to be capable of looking after the books of account themselves, but generally an auditor has to audit the books, so there is that expense as well. But if you're asking from the tax point of view, the answer is on the face of it, a trust could be a very expensive way of dealing with property, because what happens is, generally speaking, if an individual sells a property, and assuming that he's bought it for investment purposes and not for income tax purposes, he pays capital gains tax. And the capital gains tax which you would pay as an individual would be somewhere between 0 and 18%, depending on your tax rate. When it comes to trusts, the tax rate, the capital gains tax rate, is an effective 36% that one has to pay. So that's considerably higher. However, having said that, one can distribute the profits from the trust to the beneficiaries of the trust, and then they pay the tax instead of the trust. So in fact, there are circumstances where you could be paying less tax, either on the income or on the capital gains tax, because the beneficiaries have a lower tax rate than the individual who initially owned the property. However, the disadvantage of distributing to the beneficiaries is, of course, that that money is no longer in the trust, and the purpose that you had in the trust in the first place, one of the purposes was to protect against insolvency. So you can definitely bring the tax rate down to that of an individual, but then you lose the protection of the trust. So there's that disadvantage. The other disadvantage is that if it's your primary residence, the house in which you stay, which you consider as your home and where you stay, if you as an individual sell it, the first 2 million rand of your capital gain is not taxed as capital gains taxed, whereas if a trust sells it, you get taxed on the full capital gain, even if you distribute it to the beneficiaries. So that is a disadvantage. So as a general rule, if you are going to be buying a property and it's going to be the house that you're going to stay in, as a general rule, you would put that property in your individual name. If you are then going to be buying other properties for investment purposes, and you are willing to keep the properties for a long, long time, or alternatively willing to distribute the profits to the beneficiaries, then you would put the other properties that you purchase into a trust or trusts. That would be the general rule. If we're dealing with the residential properties, those are the only two wise decisions to make. You would never put a residential property in a company or closed corporation for various reasons, which I'm sure you'll deal with in your next the next one that you're having tomorrow, whenever it is. But generally speaking, for an individual, when it comes to residential properties, you either buy it in your own name or in the name of the trust. And if you're buying the property where you're going to live in, generally speaking, you would put it in your own name. The other difficulty when it comes to trust is that fairly recently, or not so recent anymore because time flies, but the receiver of revenue passed a Section 7 C, capital C, of the Income Tax Act, in terms of which he said that if you loan money to a trust, or if you try to do it through a company to a trust, you're deemed to have the trust is deemed to have to pay interest on that loan at a certain prescribed rate each year. And this has taken away some of the attraction from a trust, because of the fact that some of the benefit that you would have had by being able to donate certain assets at a certain rate to the trust each year is now reduced or negated depending on the trust. So ironically, when it comes to a trust, if you're going to buy a property, you actually want to buy it with as much credit as possible. In other words, you want the trust to use a bond as opposed to cash, because that would then negate to a large extent the effect of Section 7, capital C of the Income Tax Act. But as a general rule, as long as you're willing to distribute the income that the trust makes to the beneficiaries, the net effect, other than your primary residence, will be the same whether you buy the property in a trust or in the name of an individual, basically.
We've got another question here, Peter, from Lerato Dikhatsache, who says, is the audit required regardless of the value of the trust?
Well, the answer is yes. I guess if the trust was dormant, you would get an exemption, but the answer is yes. Obviously, if the asset is just one asset in the trust, the audit would be a very small audit.
Okay, we've got another question here. It's slightly long, Peter, so do bear with us. This one is coming in from Howard Mogetsano, who asks, so we have a holding company with 100% shares. We also have two subsidiaries with each having its 100% shareholding held in the holding company. The 100% share of the holding company are then held in the trust. The idea is to purchase the registered properties in the subsidiaries and not necessarily in the trust. But of course the shares of each of those subsidiaries is held in the holding company, further to which the 100% shares of the holding company are held in the trust. So essentially wants to get a sense of whether this is necessarily one of the perhaps the better option of setting up, especially for tax purposes. We've certainly seen those examples, right, Peter, where you set up a holding company. Yeah. So you've got holdco, and then you've got the subsidiaries, and then you do have a trust. So would you say that that's necessarily the best and the most tax efficient, perhaps? Way?
Look, the reason why they're doing it is to use the safety of the trust for the shares, which protects against insolvency. Before December 2002, that was the way everybody did it, because that would make a lot of sense to do it. But in December 2002, the receiver changed the law, and he said that in respect of residential property, and I'm only speaking about residential property, if you have a company or a CC or even a trust that whose main asset is the property, then you still have to pay transfer duty when you sell the shares in the property. So what people used to do before 2002, they put the property in the name of a company, and then when they wanted to sell the property, instead of selling the property, they sell the shares. There would be no transfer duty payable, which means either that they could charge a higher price for the property because the person was saving transfer duty, or alternatively, they would get more money as a result of it. And that's when that structure was used. So that used to be a very good structure. But when SARS changed it, he took away the advantage of it. And because a company and a closed corporation pay higher capital gains tax than an individual, and also when they distribute the money have to also pay dividends tax, and the purchaser has to pay the and transfer duty, it really doesn't make sense anymore, particularly because no purchaser would want to buy the shares in a residential property, because if they the shares in a company that owns residential property, because if they did, they would be taking over the pent-up capital gains tax that the company has to pay. So in other words, if they bought the shares in the company for R1 million and the company had bought the property for 500,000 Rand, when the company subsequently sells a property, the capital gains tax would be calculated on the difference between the selling price and the 500,000 not the selling price and the million rand that they paid for the shares. So they would end up in the future paying capital gains tax on that extra 500,000. So yes, it was a very good structure, but now, generally speaking, it's not. Because of the effect of Section 7 capital C, there may be instances where it still works, but as a general rule, that would not be the way to do it anymore. It was wise at one stage, and I'm only talking about residential property. If you're talking about commercial or other properties, then yes, you could do it that way. But again, you still have the problem of the fact that any profit that is distributed, you'd still have to pay dividends tax on. So it's a toss-up. But when it comes to residential property, and unless there's some implication in regard to Section 7C, it would not be a good idea.
And Peter, how have you found various property investors who are dealing with, residential property mitigating that there's now essentially been a change in regulation by SARS, and that was a model that they used to be as tax efficient as possible, and now it's no longer available with them. Have they found different ways to structure certainly their portfolios in order to be tax efficient, and by using a trust in particular to do so?
Well, if the property is not in the name of the company, yes, they would then buy the property either in the trust or in the individual names. If they were stuck because they bought the property in the name of a company before 2002, SARS gave an opportunity for about 2 years for people to be able to move the properties out of the trust into out of the companies into individual names, and some people took advantage of that concession and others didn't. But if you didn't take the advantage of that concession, you'd be stuck. And then the answer really is, at some stage, you're going to have to take the medicine. Either take it now and pay it in the short term, or you wait and it increases over the long term. But I'm not for a minute suggesting that it would be wise to transfer it out at this stage, because of the fact that there would be transfer duty and all other kinds of expenses involved in it. So perhaps, unfortunately, you're just stuck with that situation, unfortunately.
And Peter, before I let you go, we've certainly been speaking a lot about, buying a property into a trust, the various implications, and some of the things that viewers at home certainly need to be thinking about. One of the things that you had said, I think it was before the break, was the best time to set up a trust was 10 years ago. The next best time is certainly after people watch the show. Perhaps, give us the last bit around, why it is, certainly after this conversation, and I'm sure some people at home are thinking, well, this seems like it's fairly admin intensive, and there's so much that goes into it. Maybe it's just better if I either buy as an individual or perhaps buy into a company. Perhaps, share with us why you would say that buying into a trust, particularly a property, and particularly residential properties, because a lot of the property investors that we certainly speak to invest in residential property as opposed to, for example, in commercial property. Why it would still be a good idea, or perhaps the best way, to still buy your properties into a trust?
Okay, well, as long as we're not talking about your primary residence,
yes.
The answer would be yes, it would be a good idea, because of the fact that it protects you against insolvency. And although investors believe the assets will only go up, there can be circumstances where you could get into trouble, and it'd be really good to have the assets in a trust rather than your own individual name. Definitely, it makes no sense to buy residential property in a company or close corporation, because of the fact that you have to pay the high capital gains tax, and you have to pay dividends tax. So if you're dealing with residential properties, there is essentially only two choices, and that is in your own name or in the name of a trust. It is true that a trust is capital intensive, but admin intensive. But if you are an investor, you are involved with a lot of admin in any case, because you are almost certainly renting out those properties, and you have to then deal with the income and expenditure and all that kind of stuff. So whether you do it in the books of the trust or if you do it in your own books, I don't think it makes any real difference. Generally speaking, of course, it is also true, however, that it's no point in forming a trust if you're only going to buy one property and you're going to keep it for 2 or 3 years. Trusts are almost by definition there for people who are going to make a lot of money, or else people who are already rich. Not to say that a poor person wouldn't buy a property in a trust because of the insolvency protection, but the main benefit of a trust would be aimed more towards somebody whose estate is going to be in excess of 3 million rand. So a trust is a useful tool, and if you're looking for insolvency, a very useful tool, but it's not the only tool, and sometimes it's wise just to buy it in your own name in regard to that. Of course, the reasons why you would still use a trust, for instance, is very often people say, I want to buy the property in the name of my child, and the child is 5 years old. And that's a disastrous thing to do, because if they want to then sell the property, they have to then go to the master if the property is below a certain amount, or to the High Court if it's above a certain amount, in order to get the permission to sell the property. Whereas if you formed a trust for the benefit of the child, bought the property into the name of the trust, then if you need to sell it in the future while the child is still a minor, you could do it through the trust. So like all things, it always depends on the circumstances and your particular aim, but certainly a trust can be a very, very useful tool in your day-to-day planning and in your estate planning.
Peter, we're going to leave it there this evening. Thank you so much for joining us.
Thank you so much. Appreciate the opportunity.
And that is Peter Dykes, who's the director at Dykes van Heerden Incorporated. Well, I do hope that this has been quite an insightful, episode in as far as buying your property into a trust and understanding what goes into buying into a trust. As I said earlier on, certainly during the course of this week, we'll also be looking at the pros and cons of buying as an individual versus buying into a company. So you certainly do not want to miss that. I think as property investors, we're always trying to find different ways to be either tax efficient or certainly save every rand that we possibly can. And exploring the different ways that we can own the properties that we essentially invest in is so crucial in us saving that money. We're going to call it a night this evening right here on the Private Property Podcast. It certainly has been a pleasure to have your company for the past 30 minutes. We're back again tomorrow evening at 7 o'clock, and we do hope that, as usual, you're staying home and staying safe. See you again tomorrow.
Hi, I'm Brian Kepper. I'm a 10-time South African motorcycling champion. My family and I have chosen to live in Fourways. There's some really great suburbs in our neighborhood. There's a lot of families living in the surrounding areas, in places like Lone Hill and Cedar Lakes. What draws people to Cedar Lakes is that it's so close to Broadacre Shopping Centre, Cedar Square, and Fourways Life Hospital. Lone Hill is a major draw card for many families. It's got some great smaller commercial centres and some fantastic schools like Crawford College. From an entertainment point of view, Monte Casino really comes alive at night. There's so much on the go, and there's an incredible energy in the area. Our family just loves the fast-paced lifestyle that Fourways brings. But honestly, the thing that attracted us most to this area was the active lifestyle that it offers. As a family, we've chosen to live in Fourways because of the lifestyle and convenience, and this is our neighborhood.
Welcome to your next home. This is the perfect room if you're looking to expand the family. It's perfect. There's a kid's room or a playroom.
Did you say playroom?
Yeah, playroom.
I've been very bad.
You know what, let me give you a moment. I'm gonna feed the pancake.
Yeah, you go feed the... Whatever.
Tips for dealing with the bank. So perhaps you're renting in a property where it is run by a body corporate.
Understanding the basic calculation, income minus expenses, and you want to be left with a positive income.
It is a very tough game. It's not easy at all.
To stay ahead of knowing exactly what your clients need, what their teething issues are.
Have a joint move-in inspection.
That a lot of people that are coming into sectional title homeowners associations are, just like you described, not only first-time homeowners, but first-time owners and residents in community schemes.
They get to see the perspective from the other side of the aisle. And I think that's a really important thing to do.
It's a market that's estimated to be transacting at least 9 billion rand per year. So it's a huge market.
In order to get there, you need to be able to build up a track record.
Your cash flow model needs to be sharp.
A quote comes to mind. The best time to buy a property was about 10 years ago. The next best time is now.